is Mr. Constantine Palicarsky. He's a crime prevention and criminal justice officer in the implementation support section of the Corruption and Economic Crime Branch of the United Nations Office on Drugs and Crime, UNODC. He's a lawyer with more than 20 years of experience. Mr. Palicarsky is a part of a team based in both Vienna and in the field that is responsible for providing technical assistance to states parties to United Nations Convention Against Corruption for the more effective implementation of the convention. He has been implementing and leading anti-corruption technical assistance projects in Central and Eastern Europe, the former Soviet Union, the Pacific, Africa, Southeast, East and Central Asia, and the MENA region, with focus on corruption prevention, support to anti-corruption agencies, and effective UNCAC implementation. Please join me in welcoming Mr. Palicarsky to the podium. The microphone is yours, sir. Please. Thank you.
There we go. Yes. Thank you again for the opportunity to be here with you today. I would like to spend the next minutes discussing some aspects of the implementation of the United Nations Convention Against Corruption, particularly with regard to the declaration of interests and assets, and with a focus on the verification of the asset and income declarations. The United Nations Convention Against Corruption is the sole global legal anti-corruption instrument. It already has 187 states parties, and it boasts a unique implementation review mechanism where countries from different parts of the world, reviewing countries from different parts of the world, are performing an in-depth analysis of the implementation of the convention in a third country, with the view of issuing recommendations how to make this implementation more effective. The convention devotes a whole chapter 2, on the issue of prevention. And we all know that corruption is not a disease in itself. It's more a symptom of a disease. It's a symptom of weak institutions. It thrives where there is low public trust, where there are misaligned cultural and business incentives. To address this particular problem, the convention devotes a whole chapter to corruption, with measures detected at both the public and the private sector, and suggesting an array of measures that countries could take, of course, with full respect to the national specificity, to the national legal framework, to the national cultural aspects. Measures, anti-corruption measures that focus on development and implementation of preventive anti-corruption policies and practices, designation of specialized anti-corruption bodies, strengthening the integrity in the public sector by adopting codes of conduct, strengthening integrity of the judiciary and prosecution services, of public procurement, promoting access to information, participation of society. There are few texts in the convention that particularly look at the issue of asset and interest disclosure. And I will not speak much about the legal aspects of how the convention is being implemented, but I would rather now go into the information which we have as a guardian of the convention. UNODC is the guardian of UNCAC, on how the different countries are actually implementing these provisions of the convention. There are, roughly speaking, 3 models of asset and interest disclosure systems that countries are applying around the world. The first model is conflict of interest related. The systems are introduced in order to identify external interests of public officials and to detect incompatibilities, to detect facts which are making the public official unsuitable for a certain position according to the national legislation. That could be business interests, that could be political activity for civil servants in some countries that is not allowed, and other sorts of incompatibilities that may exist in the national legislation. The second model is the model which focuses on detection of whether actually the wealth of a certain public official has increased inexplicably. These illicit enrichment related systems usually exist in countries that have, well, criminalized obviously illicit enrichment. There are not that many countries. There are, however, examples. It is important, however, to underline that even though illicit enrichment focusing asset and interest disclosure systems are best suited for the purposes of enforcing illicit enrichment legislation, they could also be used in regular, shall we say, classical enforcement systems. The only difference there would be that while in a system focusing on illicit enrichment, a system where illicit enrichment is criminalized, the mere fact of unexplained increase in wealth could be considered a crime. In most of the other systems, that would only be an indicator which would allow the law enforcement authorities to start an investigation and to start asking the question, how did your wealth increase? It is important to underline that in the very beginning, variances in wealth, lavish lifestyle, in some countries in itself could lead to criminal sanctions, but it is mostly a reason to start an investigation. And then finally, the third model of an asset and interest disclosure system is the mixed model, which is increasingly being adopted by the states parties of the convention. It actually means that countries are trying to combine 2 declarations into one. They're combining declarations on interests, including external interests, and then they're also looking for data on the changes in wealth of a public official. Now, I didn't include that in the slide, but there, of course, is also a kind of a fourth model of the asset and interest disclosure system. Some refer to it as a transparency model. So it's basically a model where the only purpose of the asset and interest disclosure system is to provide transparency to the assets, but there are no consequences for an unexplained increase in wealth or for a mismanaged conflicts of interest or undisclosed conflict of interest. That defeats the whole idea of prevention of corruption, because after all, what we want to achieve through the asset and interest disclosure systems is not just to make the property of some people public. It is actually to identify the officials that have enriched themselves illegally or that have misused their power to serve their private interests, and then to sanction them. If there are no sanctions, then obviously, as we will see a bit later, the system will not work. There are two texts, two articles that I would like to refer to in relation to these systems. Article 8, paragraph 5 of the Convention provides for the establishment of asset and interest disclosure systems with respect to conflict of interest. And then Article 53 looks at the financial disclosure systems for appropriate public officials, which focus particularly on the increase of wealth. Now, let me go into the issue of verification, which is probably the most interesting aspect of the asset and interest disclosure. Of course, there are many other aspects, and I would not want to underestimate the importance of questions such as to whom do we submit the declarations? Should we establish a new body, or is it sufficient to designate an existing body that would be collecting the declarations? All these questions are very interesting, but they would take a lot of time. So I will focus on the issue that most countries around the world have greatest problems with. And that's the issue of verification. We could say that the first important question to ask in regards to the verification of the asset and interest declarations is which declarations to check. And it may sound absurd because it's very easy to say, well, why don't we check all the declarations? Well, we cannot check all declarations because most countries are very ambitious in their reach, in the reach of the asset and interest disclosure legislation. And most countries actually require that such a high number of officials declare their assets that checking all declarations is simply not feasible. It cannot happen physically. Only today I was discussing with colleagues in one country. They are currently appointing a commission of 6 people to verify 70,000 declarations. Now, there's no need to explain why this is not a working solution. So there must be sort of a criteria. We need to decide which declarations we will check and which we will not. There are broadly three approaches that countries are utilizing in this respect. Some countries are actually checking the declarations of all high-level officials and are not checking the declarations of the lower-level officials, or simply do not request lower-level officials to submit asset and interest declarations. The rationale behind this approach is clear. High-level officials, usually political appointments, are the ones that have the greatest power and the ones that usually occupy the positions that would allow them to circumvent certain rules and procedures and to enrich themselves. Of course, that is not to say that lower level positions don't have these opportunities, it's just that they have less opportunities. The second approach, or a second trend with regard to the criteria that are being used to select which declarations to check, is that we could check a random sample of the declarations. So every year, 10% of the declarations are being checked, for example, in Slovenia, and The other 90% are not checked. The third possible approach is to put in place something that is usually referred to as a risk-based approach to verifying the declarations. And the idea is that a verification happens when there is a need, following the receipt of a corruption-related complaint against a public official, or following a detection of a red flag or certain anomalies. For example, if the declaration has been submitted after the deadline, or if the declaration contains internal inconsistencies. The second interesting question that needs to be answered in regards to verification is how to perform the verification. And of course, the classic way of doing it is to perform a manual examination of the declarations and then to send official letters to multiple other government structures, such as the tax authority, government registries, and then to receive the response from these structures, and then to compare the data and to come up with a conclusion. This may also involve, in certain cases, checking on bank accounts or doing a more extensive investigation. In my experience, this more extensive examination of the declarations usually happens with categories of public officials that have agreed in advance to such treatment. That includes, for example, law enforcement officials or officials that work with classified information. And finally, we have the combined approach. Basically, electronic checks. Secondly, we have the electronic checks undertaken against databases of relevant information. And then we have a combined approach where the electronic techniques are usually used to identify high-risk submissions that would then be subjected to manual verification. These electronic checks are an interesting new trend. And the first time I saw them in 2001 in Bulgaria. And the idea was that the tax declarations and the asset and income, asset and interest declarations were sort of made compatible. And then the asset declarations were submitted electronically. And then the system of the National Audit Office, which was in charge of verification of the asset declarations, would electronically exchange information with the tax authority. And then if there are discrepancies, then the ball would already be with the tax authority to start a full-scale tax audit of that person, and with all the resources at their disposal to find out whether that person has actually concealed taxes or not. And then that could be used in itself as grounds for criminal for criminal investigation and criminal charges. There are much more elaborate systems nowadays to verify the asset and interest declarations. They all share certain common weaknesses. First of all, in order for such an electronic system to operate properly, all the government registries, all the government electronic records should exist in electronic format, or at least the ones that we need to use to perform the electronic checks. And not many countries in the world have an e-government that is integrated to such a degree. The next issue is that the electronic checks are only as good as the information that has been introduced to the computers manually. So at the end of the day, we always come back to the people. And this is important to remember. Computers, information systems, they're tools, they're extremely useful tools, but people operate them, and people make decisions ultimately, and these decisions could sometimes be wrong, could sometimes be correct, and could sometimes be influenced by private interests. So that has to be taken into consideration, not in order to eliminate the human element out of that equation. We cannot do that, and we should not do that. People are important, but in order to make sure that there is proper training, that there are proper safeguards, proper internal procedures and processes in place, this is very much related to also the previous presentation that we heard, the excellent presentation from Gary on the integrity of the electronic systems. The next interesting question to address when we speak about verification is who performs the verification. And here we could have separate approaches. Again, different countries are addressing this challenge differently. Usually, the verification is performed by the agency which is tasked with operating the asset declaration systems, but that is not always the case. Sometimes the verification could be entrusted to a separate body, taxation, tax services, law enforcement, and that has, again, its pros and cons, its weaknesses and strengths. Such a solution has weaknesses and strengths that need to be taken into consideration. Obviously, the agency which is tasked with operating the asset declaration system has access to all the declarations throughout the years. It is a dedicated government structure that is probably well suited to perform the verification. But on the other hand, usually the tax people in the country are the most powerful institution when it comes to examining the personal finances. And it makes sense from that point of view to use that resources. In any case, it is a decision which is being taken by each country individually. There is no such thing as best practice here. The best practice is the practice that works. If you have a strong tax authority, for example, or a strong audit office, then it probably doesn't make sense to establish a brand new structure that will be only performing the task of checking, verifying asset and interest declarations. We could use the existing resources. If, on the other hand, you have opted for a fully integrated anti-corruption body model where you bring together everything, enforcement, prevention, asset and interest declarations, if you have resources to properly fund this structure, if you have the capable people to staff this structure, then obviously it could also be tasked with operating and verifying the asset declaration systems. I would like to mention a few reasons for the failure of the asset and interest disclosure systems from our experience. Now, we all love to speak about good practices and best practices, but actually equally interesting or even more interesting would be to hear about bad practices, practices that we know that they don't work, in order not to repeat these mistakes, to learn from someone else's mistakes. And the first one, very typical one that I mentioned, few resources, many declarations to verify. Now, obviously, if 6 people have to check 70,000 declarations, they will not do it. It will take them several days to check one declaration, and then there are only 365 days in a year. And even if they work without weekends and without taking annual leave, that's not many declarations. The second, well, what is the conclusion here? What is the way out of that situation? Well, obviously there are 2 ways out of it. The first one is to allocate more resources, and the second one is to reduce the number of declarations. And the reduced number of declarations could either be achieved by making sure that only a small circle of high-risk officials make submissions, declare their assets and interests, or alternatively, by utilizing some of the approaches for selection that we discussed some minutes ago, either by only checking a random sample of the declarations or checking based on some sort of a risk assessment. The second reason why verification systems fail is poor communication between government agencies, particularly in paper-based bureaucracies. Sending a letter to another agency in order to receive information about someone's assets, and that agency replying, that could take time. And in the best case scenario, it would take weeks. In the worst case scenarios, it might take forever. So the absence of a tight, effective coordination and communication protocol is a recipe for failure. That would mean that essentially, even if the agency that is technically tasked to verify the asset and interest declarations, it may have enormous staff, it may have great resources, but then it relies on data that comes from the outside. And if the data doesn't come in, there will be no verification. The next 2 reasons are kind of connected. One is more directed towards prevention, the other one more towards enforcement. No follow-up to detected irregularities and weak enforcement. And the weak enforcement usually is hidden behind that slogan that transparency in itself is sufficient to prevent corruption. Well, it isn't, unfortunately. Transparency is showing the people that something wrong is happening. But in absence of accountability, in the absence of investigation, prosecution, adjudication, and people sent to jail, the only thing that people see is that someone is stealing money and getting rich and nothing happens afterwards. And that breeds public cynicism, destroys public trust, and tells many more people that corruption actually pays off, and it is a reasonable strategy. So enforcement is very important. When the asset declarations give us a clue that someone had enriched themselves, we need to act, and there must be a prosecution, because otherwise the very reason of existence of the asset and interest disclosure system is defeated. Of course, not only criminal sanctions are applied. Criminal sanctions are applied in the serious cases, but in many countries, administrative sanctions are applied, fines, disciplinary measures are taken, such as reductions in salaries, sometimes dismissal from service. it is interesting that in some countries, the submission of a declaration and the annual submission of a declaration is a condition, a precondition for the employment in the public sector. So from a certain position onwards, officials must submit a declaration or they're summarily dismissed if they don't submit one. This is an effective measure, probably a bit hard, but it certainly played a role in making sure that everyone submitted declarations in time. Now, I said some things about transparency that might have led some of our participants today to think that it is not important. Well, I didn't mean that. Transparency is very important. It is just that in itself alone, it doesn't help us, but it is very important. And it is very important because it makes it harder to conceal the stolen money. It makes it more likely that prosecution will happen. It puts more public pressure on the law enforcement to perform, on the politicians and high-level officials to stay, shall we say, within the borders of the law. And there are three possible approaches that we could identify when we speak about transparency of the asset and interest declarations. The first approach is that all information in the declarations is made public. And that is the case in many countries, mainly OECD member states. This is not necessarily the situation around the world. Roughly 50% of the countries are approaching such an are employing such an approach. The other half either publicize only a part of the information or do not publicize information at all. And when no information is publicized, it is clear that there is nothing to discuss. The rationale behind such a decision is that the information in the asset and interest declarations is being used by the law enforcement. Law enforcement, on the other hand, there are privacy considerations. Many countries go that way and do not publicize the information collected through the asset and interest declarations. But when some information is made public and some is not, it is interesting to look at the criteria which are being used. Often the considerations relate to privacy, but there are also interesting considerations related to the security of the official in question. In some countries, the security situation is less than perfect. And obviously, the knowledge where someone lives, where someone, where's the address of your apartment, particularly if this is complemented by information about substantial bank accounts and cars and yachts and so on, that may be that may lead to security problems for certain officials. So obviously, the United Nations Office on Drugs and Crime recommends to make all information in the declarations public. However, again, I would like to underline, we have seen and we do see very effective systems of asset and interest disclosure, where the information in declaration is not made public. However, it is well communicated to the law enforcement, and it is extensively used to detect, investigate, and prosecute corruption. I would like to say a few words on the use of information and communications technologies in the end. The primary use of the ICT is in the electronic checks and in making available the declarations to the public through internet transparency portals and so on. Obviously, the debate is still on whether this is appropriate. Some countries, because of these considerations, do allow access to the declarations through the access to information legislation, and you could receive a copy of the declaration on paper, but it is not published on the internet. And then, of course, journalists are submitting bulk requests for information under the access to information legislation, and then they publicize everything in the newspapers. This is how it usually happens. I would like to finish with a couple of words on the very interesting question: what do we do with the assets of the public officials which are abroad, which are not in our country? Well, some countries are taking very, shall we say, hard approach towards the public officials, because they say we cannot receive the information on the ownership, on the bank accounts, on real estate owned by the public officials abroad. We do not allow public officials to have property abroad, period. And this approach has also, of course, beneficial national security considerations, but it is really difficult to follow in an increasingly globalizing world. Of course, the other possible approach is to make sure that the beneficial owners of assets are known, and there are proper registers that could be consulted either directly or through the mechanisms of international cooperation, be it formal international cooperation, mutual legal assistance request, or informal international cooperation of law enforcement bodies. I would like here to mention one interesting practice. In the last several years, the countries in Southeastern Europe were working hard to come up with a mechanism to actually ensure that they will be able to obtain the information about assets that their public officials may have in neighboring countries. And to that effect, an international legal instrument was concluded, a treaty, on the exchange of information contained in asset and interest declarations. This is a demonstration that countries understand the importance of that issue. However, I would like to underline here that even in the absence of such an instrument, the United Nations Convention Against Corruption does provide for international cooperation. Countries should grant each other the required cooperation, including not only in criminal cases, but also in civil and administrative cases. And the verification of asset and interest declarations is certainly an administrative case in the meaning of the UN Convention Against Corruption. With this, I would like to finish my presentation. Thank you so much for your attention, and I will be happy to answer your questions. Thank you.
Thank you very much, Constantine. Excellent presentation. I know it has applicability to many countries in the Commonwealth, Caribbean, and I'm even more interested in the possible approaches that have been suggested regarding how to treat with the outstanding declarations. Might I ask the first question of you in the context of the presentation and more so the electronic submission of one's assets and liabilities by way of a declaration? You did mention that one point and a very important what I would call platform for that to work would be, for want of a better term, the interconnectivity between all the government agencies, where one would have information from tax authorities, from all other authorities, the titles office, everything there. But I'm asking you by way of the first question, have you seen anywhere in the world where there is not this interconnectivity between all these databases, where even the submission of or the e-filing of statutory declarations has worked, is working, or is effective in the absence of this interconnectivity of the databases?
No, I don't think that we have it in full. I did mention that in the beginning of 2000s, beginning of the century, I've seen such a system where the National Audit Office, which was in charge at that time of collecting the asset and interest declarations, was linked electronically to the tax authority. And then these two systems were made to work together. And the assumption was that the tax authority has a lot of information on the assets of the person, obviously. The discrepancies between the asset declaration and the data with the tax authority would then trigger a tax investigation, and then they would do an investigation the old-fashioned way, the classical way. This is what I have seen. I have heard about other systems. I have heard that about, for example, Armenia, that has introduced a fully integrated solution of that kind. But I cannot really tell you how effective it has been, given the fact that 1 year after the submission of that information, they disbanded their anti-corruption agency and established a new one. So I do know of a number of cases where such a connectivity has been achieved, but a full connectivity, full interconnection with all stakeholders of all registries, I don't think we have that in a moment, no.
Thank you. Are there any other questions before I pose my next question?
I wonder whether I could say a couple of words while the colleagues are still thinking about the questions. I would like to go back to Professor Johnston's presentation, which was excellent, and it echoes on a research that we did some time ago on the procurement in small islands. And we were looking there at the specificities of the small islands, island communities, and these specificities obviously made impossible the use of many classical anti-corruption strategies. For example, ones related to conflict of interest management. It is very difficult in a small community to find people who are totally disinterested and who are totally separated from the others. Everyone knows everyone. There are histories of relations. And that was seen both as a problem and as an opportunity. Because in small communities, transparency is not an issue. And that was mentioned in the presentation, the excellent presentation that we heard. In fact, people know who is doing what. So the question here is not so much about let's make a website. It's more about what shall we do about it.
Yes, very important point. Back to where we are, I would say you did say there's a balance of about 50% in terms of what some nations are doing in terms of their preparation, in terms of receiving declarations. But let us think of the Caribbean, and I know the member countries, I believe all are still relying on paper-based submission of declarations, and paper-based submission where certainly I hope not like the example you gave of 6 persons trying to go through 60,000 declarations, but certainly is there any system in place, and I'm still going back to some sort of mechanical process, outside of that, hiring of more people, having more boots on the ground, having 40 or even 100 people going through the declaration process? Is there any software out there that would assist a declaration form being subjected to the software or in a computer-based system that would assist to collate, that would assist to assist in terms of analysis of the information?
I have seen simple electronic solutions such as Excel forms that are being submitted. So the first electronic declaration that I have seen was actually a fairly simple Excel form that was submitted by the public officials on a USB stick, and that worked, and that did speed up the process of the processing of the asset and interest declarations. I wouldn't say that it speeds up the verification, because in order to properly check on the declarations, it is not enough to simply see whether all the fields in the declaration were properly filled, whether all boxes were ticked. You could do that with a fairly easy Excel tool, but when we get to the point of actually examining the content, when we need to answer the question, okay, that person declared that they have $100,000 in cash at home and two bank accounts, $50,000 each. Now you need someone who will physically go and check whether this person has $100,000 in cash, and then you need someone to go and speak with the banks and find out whether the information about the bank account is correct. That cannot be done electronically, not at this stage, not in a moment, maybe in the future. But I think that a full verification will have to rely a lot on the labor of qualified and well-prepared investigators, auditors, while of course the electronic tools could be used to detect small inconsistencies, usually formal mistakes, that may be a red flag of a lie. Because when people lie, they make mistakes, and then there are inconsistencies, and of course then you could launch a full-scale manual investigation.
Thank you, Constantine. We have a question from Debbie Gardner from the Integrity Commission in Jamaica. Are companies in your country applying to become government contractors required to disclose the beneficial owners of these companies?
Yes, there is a legal requirement. The beneficial owners must be known. Of course, there's always the question of whether people could lie, and the answer is yes, someone could lie, but that is already a submission of false statement, and that could lead to criminal sanctions. Normally, people don't lie, but some might. No.
Thank you very much.
It is not only about government contractors. It's actually it's actually mandatory for all companies in the country, in the jurisdiction.
Thank you very much. It appears that there are no other questions. It was such an excellent presentation that no one has any questions to ask. Excellent presentation. Thank you so much. And I know my colleagues throughout the Commonwealth who will certainly make contact with you, because I think there's a lot more in terms of this area that they would love to explore. So I thank you very much. And certainly, I know we'll utilize a protocol through Candice to get to you, but certainly we will be in touch, certainly.
I would be delighted. I'm sending you my email address. It's in the chat, but you of course already have it. In case if you would like to share with any of the participants, I will be happy to try and answer any further questions. Thank you.
Thank you so much, Constantine. Thank you. Please feel free to join us for the rest of the day and the proceedings that follow. Thank you.